Law program in public law. And I'd like to now introduce Professor Scott Silliman, who is a professor here at the law school and executive director of the law school's program on law, ethics, and national security.
Thank you, Libby. I, too, want to thank both the Federalist Society and the Duke Program in Public Law for sponsoring this event. We really are privileged today to have Judge David B. Sentelle, who is the Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit. He was born in a small town in North Carolina called Canton. Canton, for those of you who don't know where it is, it's west of Asheville and east of Waynesville, right? Am I correct? And went to the University of North Carolina over there, both as an undergraduate and to law school over there. And then, after he graduated from law school in 1968, went into private practice in Asheville from 1968 to 1970. And then he was the assistant U.S. attorney in Asheville from 1970 to 74. He then became a judge on the North Carolina General Courts of Justice in Charlotte and served in that capacity from 1974 until 1977. Then went back into private practice, but this time in Charlotte from 1977 to 1985. In 1985, President Ronald Reagan nominated Judge Sentelle to the federal bench in the Western District of North Carolina, where he didn't serve too long, because 2 years later, in 1987, he was recommended by President Reagan to fill the seat which was being vacated by a judge, now Justice Antonin Scalia. So it's a pretty prestigious seat. Actually, Judge Sentelle has been on the circuit court for that period of time, and then just February 11th of this year became the chief judge of the U.S. Court of Appeals for the District of Columbia Circuit. He's been a visiting professor on 2 occasions at the University of North Carolina, his alma mater, and also, for those of you who are interested in national security law, has been teaching for a number of years at George Mason University School of Law up there. And I can think of nothing better, because Judge Sentelle, I got to tell you, writes many of the pivotal opinions in national security law, and I couldn't think of anything better than studying under Judge Sentelle in national security law. I've had the pleasure of knowing Judge Sentelle for a number of years, and it is indeed a great personal and professional pleasure to welcome him to Duke Law School and to introduce him today. Judge?
Thank you, Scott. If Scott told you how many years we've been friends, it would both reveal how old we both are, and the fact that he also went to the University of North Carolina. At the same time, I think it's been, about 47 years since you and I would have met at the University of North Carolina and been classmates in both undergraduate and law school. When Scott speaks of my experience teaching national security law, I have to say that I consider him perhaps my guru in national security law and the person who first suggested I might teach the subject, and it has been a great experience to do so. Those of you who have had Professor Silliman's class in national security law know that he is a genuine authority on the subject. And if you haven't had the class, people way away from Duke Law School will recommend him as being one of the leading scholars in the field of national security law. Those of you here from the western end of the state and recognize the name of Canton, North Carolina, I once gave one of these speeches on some subject up in Washington. Someone introduced me as having been born in Canton. A young woman came to me afterward and said I could not have been born in Canton because there's no hospital there. To which I assured her that I had neither been sick nor in need of an operation. So you're only required to go to the hospital if your mother does, and she didn't, so I didn't either. Well, a few weeks ago, Professor Silliman asked me to give him a topic for this address. At the time, I told him, "Bring him back alive, extraordinary rendition in the war on terror." I intended to write a orderly, organized treatment of that subject. I never got it done. In fact, a more accurate title would probably be "Some Random rather rambling thoughts generally related to the subject of extraordinary rendition and all related to the subject of the War on Terror. If I miss something you'd like to cover, we will have a Q&A period. You can ask any question you want to. I don't guarantee that I will answer that question, but you can ask any that you want. Those of you who have heard me speak on subjects related to national security before, which would be Scott and maybe one or two other people, in fact, generally related to federal law at all, will know that I believe that judges speaking on controversial and litigable topics best serve their own interest and the interest of the profession and the advancement of the debate by raising questions more than by supplying answers. I'm going to be staying close to that format today as I give you a once-over of questions loosely tied to the subject of extraordinary rendition, and again, all tied to the subject of the War on Terror. The first question is one to which I will attempt to supply at least a partial answer, and that is, what is meant by the term extraordinary rendition? Well, rendition in international law refers to the transfer of persons from one nation state to another for the purpose of arrest, detention, prosecution. Rendition in the classic form involves the courts of most nations or the diplomatic services of one nation and the courts of another. Extraordinary rendition is when we do it without the courts. That is to say, extraordinary rendition is the extrajudicial transfer of persons from one state to another, generally for the purpose of arrest, detention, and or interrogation by the receiving state. That's from Michael John Garcia, Renditions and Constraints Imposed by Laws on Torture, a report done for Congress. But the term may also include the transfer of aliens suspected of terrorist activity to third countries for the purpose of detention and interrogation. That may be where you've been most likely to hear media use of the term extraordinary rendition. Now, the practice of extrajudicially transferring persons from one nation to another, or at least to the custody of the second state, has been the subject of much controversy in the public debate over the tactics employed by the United States in the War on Terror. Sometimes the critics of extraordinary rendition are talking about discrete cases of suspected terrorists or aiders and abettors of terrorism who are scooped up by CIA agents or others and transferred to a third state for questionable questioning procedures. Other times, the critics of the use of extrajudicial transfer use the term extraordinary rendition very broadly to include those who are taken in or near combat situations and transported to Guantanamo. In general, the climate is a blurred weather mass of accusations, recriminations, and defenses of extraordinary tactics in the extraordinary war on terror. I doubt that I will clarify that blurred weather mass today, but perhaps I would at least help you see where the parameters of it are and how the air is flowing. In examining the link between extraordinary rendition and the war on terror, I began with a question of very broad scope, and that is the term war on terror an apt or an inapt term, and what are the dangers and the whole idea of conducting a war on terror? I should say at the outset, this is a backing away from the question you think I may be raising, the difficulty with describing this event involving terror as a war does not come from the fact that the war is undeclared. Opponents of the war in Vietnam used to argue that the war was unconstitutional because only Congress can declare war. There had been no declaration of war. Before Vietnam, during the Korean conflict, some Republicans said that Truman was ignoring the Constitution by fighting an undeclared war. Do any of you know how far back this country, who was president the first time other than Scott, know who was president the first time this country fought an undeclared war? All right, it was not George Washington, but it was the next president after George Washington. As far back as the Quasi-War, the naval war with France, you had political opponents of President John Adams saying this is unconstitutional, it's an undeclared war. Well, in Bass v. Tingey, B-A-S v. Tingey, which people tell me should actually be pronounced Ba v. Tingey, but I've been pronouncing it Bass for a long time, and he's dead anyway, so who cares? The Supreme Court was essentially asked the question whether war could exist without a declaration of war and still be constitutional. The Supreme Court had no real difficulty with that issue. Although the justices in those days delivered their opinions seriatim, that was one of the very few significant cases decided before John Marshall came on the court and introduced the custom of the opinion of the court. Bushrod Washington wrote the lead opinion in that case, and he adopted terms from international law. Now, we think of international law as being something very new. Well, the parameters of it may be, but the existence of it is not. At the time of the Constitution, at the time of the Ba v. Tingey case, there were several scholars, including Pufendorf and Vattel, who had already written on international law, or what was called the Law of Nations. They had discussed, or some of them had, the concepts of the perfect war and the imperfect war. Both were wars. Justice Washington did not cite the works of the scholars, but he had obviously become familiar with them. Clearly at the forefront of his mind, he noted the difference between the perfect and imperfect war. He wrote that when Congress declares a war, it becomes a perfect war. The whole nation is committed to it. If it is a limited war, it can be an imperfect war, but it is nonetheless a war. In that context, Justice Washington was able to hold that France was an enemy for purposes of the salvage statute because a war could be constitutional and still be a limited, undeclared war. War still has a role even when it's not declared. What we sometimes forget is that even at the time our Constitution was being written, the idea of an undeclared war was not at all abnormal. The framers were aware that the Europeans had for decades, even centuries, been fighting war without declaration. The framers were the educated men of the time. They had international law texts brought to them. They were familiar with European events. Hamilton, in Federalist number 25, alluded to the fact that the nations, as he put it, of late, had been of the custom of fighting wars without declaration. So it appears clear that when the framers said Congress could declare war, that did not mean that a limited war could not be made without a formal congressional delegation. Well, with that historical background, it doesn't trouble me at all that this war on terrorism is not declared like the other wars without declaration that we've had in history. There is congressional authorization, but not declaration of war. Truman did not have a direct congressional authorization for the Korean conflict, but he had the UN treaty, as the UN had taken action in Korea, and he was acting under the ratified treaty. President Adams was acting, among other things, under the Salvage Act. President Johnson entered Vietnam under the Gulf of Tonkin Resolution, which he said was like Grandma's nightgown, it covers everything. There's always been some form of congressional authorization for limited wars, virtually always, not always, virtually always been some congressional authorization for the limited wars, at least post hoc. That's not the troubling part of calling this a war on terror. President Bush has the authorization for the use of military force. The troubling part is, how do you define the enemy in a war on terror? And that does have a lot to do with who you can rationally subject to rendition, either in the narrow sense of extraordinary rendition or the broad sense of including the combatants. Zbigniew Brzezinski has recently, fairly recently now, written that the problem is calling it a war on terror. We didn't say in World War II that we were fighting a war against Blitzkrieg. We were fighting a war against the Germans, the Japanese, their allied nations. When we say we're fighting a war against terror, terror is a tactic. It's not an enemy. Wars, particularly declared wars, but even undeclared limited wars, are fought against nation states. It was not the case with the Barbary pirates, but generally when we fought a war, it's been against an identifiable state enemy, not against an idea, not against a tactic. So is this styling of the conflict as a war on terror apt at all? Is it fraught with dangers with regard to how we conduct it or how we conduct the peripheral acts of rendition? Like I said, I'm going to ask more questions than give answers. Well, there's a danger illustrated in some of the separate opinions in Hamdi v. Rumsfeld, the Supreme Court decision from 2004, and Rasool v. Bush, decided the same day. Specifically, Justice Kennedy has noted that when we've taken prisoners of war in the past, we've been able to say that they are held as prisoners for the duration of the conflict. That presupposes that you can tell when the conflict is over. When you're fighting a war with a nation state, you don't know what day the war is going to end, but you know there will be a date on which there will be a formal cessation of hostilities, there'll be a peace declaration, a peace treaty, a surrender, a definable day when it's over. When we say we're fighting a war on terror, how do we know when it's ending? If we're holding people for the duration until the cessation of hostilities, are we holding them for such an indefinite time that we may be holding them for years? We've been holding them for years, for decades, for lifetimes, without ever having a definable point at which their status as enemy combatants would cease and permit us to release them. There are therefore real consequences to this idea that we are following the model of warfare. There is perhaps an ineptitude to the use of war in the title of our struggle. And some of those most dire consequences fall within that broad area of extraordinary rendition, particularly if we lump the Guantanamo alleged enemy combatants under that same rubric. Resorting to my format of asking questions, how do we deal with the people who are taken in custody in a war on terror? The model in Guantanamo is not the model of international rendition in criminal law or anything else in criminal law, and yet we seem to be asking the courts to pass on rights that have been developed more in the field of criminal law than anything related to war or international law. Our handling is rather structured on the traditional handling of prisoners of war. Prisoners of war in a conventional sense are people that you can't release, but you can't put on trial. You don't put on trial. In terms of the war on terror, what do you do with people that you can't try, but you can't release? With respect to the Guantanamo-type prisoners, if they were prisoners of war in a traditional war, we'd know that that day would come. But what happens to those held as POWs when there is no nation state to sue for peace? Granted, if they are in fact unlawful enemy combatants, it may be fair to say they got what's coming to them. But is it not possible that among those taken on the field of battle, there are some who were just shepherds who were out there with their sheep at the place where the terrorists decided they'd fight from? If the prisoner of war model is flawed, and it is flawed, is the criminal justice model also flawed? The criminal justice system is not designed to deal with the kind of conflict that's going on in this war on terror. The criminal justice system, including the norms of international rendition, is designed to prevent people from killing people and people from breaking things. In war, even the war on terror, the goal of everybody in the field is to kill people and break things. They're not doing it in the individual way that the criminal justice system is designed to address. They're acting in mass in the ways that armies are usually designed to function. The criminal justice system is not a big enough boat, is it, to handle that kind of conflict? Now, with respect to those individuals who are not the Guantanamo-type rendered prisoner, but those who are allegedly taken from some other country to a third country for interrogation or torture, would the traditional model of international judicial extradition be effective? Suppose we do not actually have an extraditable crime for which the person is suspect. Normally, when you extradite somebody, you have to have a crime that's a crime under your law that would be a crime under the law of the state rendering up the person. It has to be specific, and they're sent for that purpose. But suppose we don't have that on one of these people in a third country, but our intelligence resources have strong, perhaps even irrefutable proof that the person is knowledgeably involved in dramatic schemes of terrorism against the United States. Suppose our intelligence resources have strong, even irrefutable intelligence to the effect that these persons can furnish information that might save hundreds, thousands, even millions of lives. Do our leaders dare leave them unquestioned in some other country if it would be possible to use extraordinary means to bring them into the hands of interrogators? Now, I would note that I do not intend this to be an advocacy of of the use of torture once the persons are in the hands of the interrogators. That's a different question as to how the interrogation should be conducted. I only mean to raise questions as to how the interrogators would have access to the person at all. Back to the Guantanamo prisoners. I'm not suggesting we have to depart from the POW model, although we seem to have gone pretty far away from it already. But I do remain unsure that we're equipped to deal in the courts with the problems that are raised by prisoners inherent in that kind of undertaking. Are they entitled to due process? What process is due? I've written, lots of judges have written, that due process means that process that's due under the circumstances. What are the processes due under the circumstances of these persons held as alleged enemy combatants, unlawful enemy combatants in the war on terror? How do you conduct discovery? How does the State Secrets Doctrine or the Classified Information Procedures Act, protecting the release of classified information, apply in such a case? The issue of holding people who cannot be tried by normal means and cannot be released raises practical problems as to how you deal with any due process for those persons. What do we do with information that we cannot release, but we cannot, consistent with due process, withhold? We've had plenty of cases in the past where we invoked the Classified Information Procedures Act to protect classified information. But at least in my circuit, in the Eunice case, which has been adopted in other courts, we were able to say that we do not have to reach a balancing between the interest of due process and the release of this information. The prisoner has to show that the defendant has to show that the information is helpful, but relevant and is material in the sense of being helpful to his defense. In Eunice and lots of other cases, there couldn't be that showing. In Fernandez, in the Fourth Circuit, and some other cases, they have actually ordered the prosecution to be dismissed when it was information that would be relevant and material to the defense. But what do you do? That's fine when you got a criminal defendant and the government can make the decision. We don't want him bad enough to release this information. But what do you do with persons whom you're reasonably sure that the day you turn them loose in their third country, they're going to head back for the Al-Qaeda headquarters to be deployed to shoot other Americans? Now, Hamdi v. Rumsfeld was not itself an extraordinary rendition case, but it involved and discussed a lot of the same problems. Hamdi was an American citizen who was captured as an alleged enemy combatant during the military operations in Afghanistan. In a habeas proceeding filed on his behalf, the Supreme Court ruled in its fragmented opinion that an American citizen whom the government has classified as an enemy combatant is entitled under due process to a meaningful opportunity to contest the factual basis of his detention before a neutral decision maker. The Supreme Court is still considering, and so are we on the lower courts who are awaiting the Supreme Court's decision, the implications of the due process clause to the non-citizen who's held in the POW type rubric at Guantanamo. Granted, Congress has provided process under the Detainee Treatment Act, which was a successor to the Military Commissions Act, which says that habeas will not lie for prisoners in Guantanamo, but provides other process. The question that Professor Silliman and others have raised, and the Supreme Court may eventually be pondering if they're not in the present case, and they may be in the present case, is whether there is an adequate substitute for habeas found in the Military Commissions, the Detainee Treatment Act. That only arises if they hold that the prisoners at Guantanamo are entitled to habeas. Generally speaking, we'd say prisoners of war are not entitled to habeas, but are these prisoners of war? Are they entitled to different process? It's unclear what will be left after the Supreme Court decides the Detainee Treatment Act that is now before it in the Boumediene case. And I realize, Scott, there are many ways of pronouncing Boumediene, but that's the one we adopted on my court. Every lawyer who got up argued a different pronunciation of Boumediene. Boumediene. In any event, the Supreme Court has it now. It's been argued. And we hope they will tell us what we have to do, because we know we're going to have to do a whole lot. The Detainee Treatment Act provides for review of the combat status tribunals, the status of these prisoners, legality of their detention before my circuit. We have a lot of those petitions, and we have a lot of petitions in habeas form filed before our district court awaiting our acts. The Supreme Court's going to make one or the other of my business. Okay, so this is a form of rendition that is extraordinary in every sense. But again, we have that rendition of the discrete subject who is being taken to a third country or somewhere else for interrogation that may involve torture. If we can't try the prisoners at Guantanamo and we can't turn them loose, can we leave in a third country somebody we know has critical intelligence information? We can't afford for him to be out there, but we can't obtain him by the ordinary judicial processes of extradition. If the country to which we're sending him says we don't torture, can we accept their diplomatic assurance of that, even if they've done so in the past? If we have somebody who's reached the point where we can turn them loose, but we know they're going to die if we send them back to their own home country, what do we do with them? Again, suppose he says, I don't want to go to that third country. They're in league with my old country. They'll torture me there. Can we accept diplomatic assurance that they won't? Now, finally, is extraordinary rendition inherently a bad or even suspect thing in every case? Suppose a country goes into another nation with which it has no extradition treaty, and it kidnaps a person who is living peacefully there under an alias, say his assumed name is Ricardo Clement. They take him back by force to a country where he's never been to try him for a capital crime and put him to death. Is that inherently a horrible thing? Well, suppose that Ricardo Clement's true name was Adolf Eichmann, and suppose he was one of the principal architects of the Holocaust, and he was responsible for literally millions of deaths by reason of genocide. And if you don't go take him, kidnap him by way of extraordinary rendition, he's going to live out his life peacefully as Ricardo Clement. You know, that's not a hypothetical. That's exactly how that happened. Should we condemn Israel for that extraordinary rendition? Should we? The question of the essentiality of kidnapping, the inherent evil, if it is evil, of extraordinary rendition, lets me end with my format of asking questions rather than giving answers. If the courts are not involved in some renditions, does that mean that the executive branch is simply going to be permitted to run amok? Is it a rogue elephant acting without limits? Well, let me say this about that. If we have a doctrine of political question, and we seem to have had one since John Marshall was on the court, then isn't it going to be the case that something that is as fraught with national security concerns as extraordinary rendition is often going to raise questions which will fall within the political question doctrine and outside the realm of the courts? Congress took us out of a lot of the cases in the Detainee Treatment Act, but there will be others that will come up in which there will be what we might call political questions raised as well, whatever the Supreme Court does with the specific cases at Guantanamo. If the courts are not involved in extraordinary rendition, does that mean that the president is able to act like a rogue elephant? Well, let me remind you that the framers divided the government among three branches of government, not two. They gave almost none of the national security and intelligence and international relations powers directly to the courts. Title III, that little title that creates the courts, the closest thing it comes to a mention of national security or international relations is the treason clause. But for the most part, national security powers are divided between the president and the Congress. There are those who would stress that there are inherent powers in the presidency not specified in the Constitution, and that's not totally without foundation. The granting clause in Article I and Article II are not worded the same way. Article I grants to the Congress the legislative powers herein granted. Article II grants to the President the executive power. It doesn't say herein granted. So some read an implication that there is an inherent executive power that does not reside in the Constitution per se. Congress has over the years taken a lot of implied powers under the express grants in Article I. But the President started out with a better argument for implication of additional powers. In the Curtis Wright case in the 1930s, Justice Sutherland said that sovereignty governs in foreign affairs and national security, and that the sovereignty had passed from the crown to the president without regard to the Constitution. Now, he was a bit unclear on exactly where the sovereignty lay during the period between the Declaration of Independence and the creation of the Constitution. There was no president at that time. But he would have said that the president had the same powers in international that the crown did before the Revolution. Now, that view has not been followed by its terms in any case that I'm aware of, but there are still those out there, and you're envisioning Professor John Yoo in your mind right now. You all don't know John, but he was at Cal Berkeley, and he would still use that doctrine today to justify saying that the president could do pretty much what the king could do in international affairs. The Truman administration actually argued that position in the lower courts in Youngstown Sheet and Tube, the steel company case that you may have run into in con law, national security law, or a few other places. That argument was so poorly received in the Court of Appeals that the administration did not phrase it that way in the Supreme Court. Congress has enumerated powers and implied powers that deal with national security. In fact, they have more enumerated powers in international affairs than the president does. If the president begins to act like a rogue elephant, the legislative branch has the power of the purse, the power of oversight, and a lot of other constitutional powers. They can refuse to fund what the administration is doing. They can call administration officials to Congress with the power of subpoena to let the Congress know what's going on. There was a science fiction spoof a few years ago where Mars attacked the Earth. And one of the first things the Martians did was blow up Congress. That came with mixed feelings to the American people. But the president made his report to the people, and he said, 2 of the 3 branches are still growing strong, and 2 out of 3 is not bad. Well, 2 out of 3 isn't bad, even if the courts are not involved in some of the international affairs by reason of the political question doctrine. or by reason of the Detainee Treatment Act, there are still 2 out of 3 branches of government who are involved, and the Congress is a strong branch. We've seen that pretty handily during both of the last 2 administrations when there were significant periods of time when Congress was in the hands of one party and the White House was in the hands of the other party. Congress is a strong factor. Congress has power of the purse, power of oversight, and ultimately a power that is greater than either of those. I'm not talking about impeachment, which is the capital option, the nuclear option, but there's a still greater power that Congress has than that, and that's the political power. If the president is generally running beyond the bounds of propriety, the Congress can go back to the people. They can seek to have the president impeached and removed in extreme cases, but more commonly they can go back to the people and display what's going on and ask the people to put in power officials, Congress members, and presidents who will do the right thing. You've seen that happen in various elections over the years, and I won't try to specify which ones because I'd be accused of being more political than judges ought to be. But let's say it's happened both ways with both parties. You see, I think Sutherland missed the point when he said where sovereignty lies in that Curtis Mathis case. The sovereignty did not pass to the president. Sovereignty passed to the people of the United States. We, the people of the United States, formed a compact in the Constitution, and that's where the sovereignty lies. We may have ceded to Congress certain powers in foreign affairs. We may have ceded to the president certain powers in foreign affairs, but the sovereignty lies with we, the people. Well over 200 years after the Declaration of Independence, and somewhat over 200 years after the Constitution, we're still governing ourselves in foreign affairs with something called national security law, and that word is important. A great many countries of the world just have national security. They don't have national security law. Even in an era when the courts may not speak or may speak with muted voice, we are still bound by law. And even in those areas where there is great public disagreement and great commitment to the executive alone, none of us have any fear that that door back there is going to sweep open and stormtroopers will come in and drag me out, or Professor Silliman out, or any of you out because of the views we've been expressing on extraordinary rendition or in any other matter of public policy. We still have national security law. We're still a nation governed by an operative constitution. Big question. Is this a great country or what? So I will confess to having gone far afield from the subject that I told Professor Silliman I was to speak about, but I hope I've given you at least a little food for thought on the questions raised by the conduct of something called a war on terror and the use of extraordinary means to take persons into custody and to move them from one country to another. Are the courts to play a significant role? If so, what? If the courts do not play a significant role, is there a danger of lawlessness? I'm not going to try to answer those questions. I have to answer enough questions in the opinions we have to give in court, and I do purport to respond to the questions you're going to ask me today. But I think they're questions that you should consider, and I think they're questions which the branches of government will have to face in the days to come. I think we have time left for some interaction.
Thank you, Judge. I don't know whether you realize it, but you just had a mini course of national security law. We do have about 15 minutes, so we'll open the floor to any questions you might have for Judge Sentelle.
Yes.
I'm interested in the comparison to prisoners of war, and I confess not having taken national security law, so this might be more basic than it should be. My understanding of prisoners of war is that most of those rights come from treaty obligations.
Yeah.
If we didn't have those treaty obligations, what rights would prisoners of war have just from the Constitution or statutorily? And why isn't that the base of how we treat people outside of the prisoner of war group?
That's an excellent question. It would be a matter of customary international law if there were not express treaties. International law comes into, it's, Scott, at any time feel free to jump in. International law comes in two sorts. And customary international law is the first sort. The formal sort involves treaties and international agreements. So I think it'd be a matter of customary international law if there were no treaties. We could also have domestic law that governed the conduct of our forces. Now, as to whether the prisoners would have any rights in the American courts, there's a classic case that arose out of World War II. It came actually to the Supreme Court in 1950. Eisentrager involved Germans who had been convicted of war crimes and were held in Germany by forces in places under the command of American forces. They sought habeas relief in the United States courts, and after the district court threw it out for lack of jurisdiction, the Court of Appeals, in which I now serve, long before I served on it, reversed the district court. The Supreme Court put back the district court's decision saying that habeas did not lie for persons held outside the United States. That's sovereign territory of the United States. That's what was at issue in the Detainee Treatment Act and the Military Commissions Act, as they've gone to the Supreme Court, is, does habeas lie for the prisoners at Guantanamo? There is at least jurisdiction under Rasool. I get Hamdi and Rasool back. Under the Rasool decision, 6 justices at least found jurisdiction. Now, whether the right of habeas still lies is still to be litigated in the case that's now pending, the Boumediene case, which again involves prisoners at Guantanamo. That may be answered more than your question, but did I catch your question in there somewhere?
Yeah, I think so.
Okay. Back there.
Thanks for coming. Thanks for offering these provocative questions. I'm wondering, in your talk, you spoke a little bit about rendition going one direction where the United States government, for example, would be obtaining a rendee, I don't know if that's a word, and taking them to our country. I'm wondering if there's a worthwhile question on whether there could be a distinction between when it's going that direction, bringing them into this country, and wherein they would obtain whatever sort of status and rights, between that and when the rendition is going the other direction, where it might be someone that the U.S. is taking into custody and they might be transferring them to, say, Egypt or somewhere where they might not obtain the same kind of rights that they would have.
There is a lot of controversy about that. In fact, that's a fairly short answer, but it's about a complete answer that yes, there's a lot of controversy about that, reaching the level of political controversy. The allegation being that the United States administration has deliberately put people in the hands of regimes that would torture them for information. I'm not passing on the right or wrong or whether the allegations are true or false, but that's the controversy that's ongoing. Yes.
You spoke, one of the difficulties of putting extraordinary rendition into a ordinary rendition framework is the framing of the legal claim against the person. You've wondered what to do in situations where we might not have a legal claim against somebody who we nonetheless knew was a terrorist or involved in some way in a terrorist organization. Would there be any basis for locating a legal claim against that person in customary international law in a way that would then make them subject to a court process in any country?
I think the better way, more efficient way, would be, if possible, by diplomatic agreement. I mean, what I described to you as the norms of extradition apply when the courts are going to be involved. But there have been lots of things like POW swaps, like the swapping of spies. You know, in the old Cold War days, the United States would catch a Soviet spy and he would know he would be held here often until the Soviets caught an American spy. And then they'd meet at a bridge somewhere in Europe and crossed on the way to each other's places. So there are ways to do it by diplomatic, but I don't know that there would be much of a way when you did not have, when you were not initiating from a legal claim any kind of court rendition, anything approaching extradition. Again, Scott, at any time you have something.
I think your comment about political is best illustrated by the 5 Brits that were released from Guantanamo Bay because of strong pressure from Tony Blair to Bush, and that was purely diplomatic. Whereas, as Judge Sentelle has said, when you accept the argument that those who are unlawful entity combatants are going to be detained, even POWs are going to be detained until the end of the cessation of hostilities, there is no legal argument that applies. It's all diplomacy that's going to apply. The State Department has been working very hard on it.
Yeah, there actually are not nearly as many people at Guantanamo as there once were at Guantanamo. There have been diplomatic releases, the 5 Brits being the most conspicuous, and there have been some where the military has decided we're not going to hold that person anymore. He doesn't know anything else, and maybe knew nothing to begin with. Yes.
Speaking of Guantanamo, other than matters purely pertaining to convenience, does it really make any difference whether or not we hold the people that we're holding at Gitmo or a prison camp built in the middle of the White Sands Proving Grounds inside the continental United States?
It makes a heck of a lot of difference to a lot of people.
And, well,
The question of habeas, I didn't go into the greatest detail, that's why we have a Q&A session. Eisentrager held there's no habeas right outside the sovereign territory of the United States. There are habeas rights for aliens held in the sovereign territory of the United States. Now, one of the questions before the Supreme Court, which vexes the court and may result in division on the court, is what applies in Guantanamo. Because Guantanamo is not within the classically defined sovereign territory of the United States. As Justice Kennedy in particular pointed out, was it in Rasul or Hamdi, where he pointed out the unique nature of Guantanamo. Guantanamo is under a perpetual lease, but it's still part of the sovereign territory of Cuba. However, as in a functional sense, Justice Kennedy would say, and it's hard to disagree with him, that it has functionally the same attributes as the sovereign territory of the United States. But unless and until it is definitively said that all the laws of the sovereign territory, all the rights of the persons held there apply in Guantanamo, it makes an enormous difference whether a person is at Guantanamo or White Sands, New Mexico.
And the reason I ask this is because during World War II, of course, we kept PWs inside the continental United States, both German and Italian. Did they have a right to habeas that they just didn't get around to exercising, or?
We might have been better if they had tried to exercise one then, because I think clearly the Supreme Court at that time would have said no, and we'd have precedent to go on then.
Which brings me to my last one, which is, what if the President of the United States, I'm not suggesting he should or would do this, but what if he just said, thank you, courts, I'm happy for your opinion, but it doesn't matter. I'm the commander-in-chief, and I'm conducting this war. Doesn't it, I mean, what are the courts going to do? I mean, this then becomes a political question, which is, wouldn't you agree, is probably where it should
At
begin and end
least
in
the
the first place?
first president I know of to take that stance was Andrew Jackson on the removal of the Cherokee
Indeed.
in the 19th century. Mr. Marshall has entered his opinion, let him enforce it. And it really wasn't enforced. It had tragic consequences, and it was not good for the rule of law. I cannot say that there haven't been other instances where precisely that has happened, but it hasn't happened as blatantly and openly as Jackson did it, that I know of.
But again, the difference between those that we detained here, General Germans, were they were classified as prisoners of
Yeah.
war, just like Saddam Hussein
Right.
was a prisoner of war. So you've got to distinguish between what we can do with prisoners of war and what we cannot do. Of course, they were being held under the 1929 Geneva Convention.
Yep.
not 19.
And it is the United States' position that the conventions do not apply because these are not prisoners of war, that this is still a different status that is not prisoners of war. But there is no nation state who's a party of a treaty here to act under. And the argued view, at least, is that there are no individual rights created under treaties, that they are, unless they expressly say so, and that these are rights of nation states who are parties to the treaty. Now, there are provisions of the treaty which expressly speak to non-parties, but whether that refers to non-nations is still another question. So there are more questions than there are answers in this field. Yes, ma'am.
Building off of your point that they're not POWs that we're talking about, and that the Geneva Conventions mentions non-parties. I kind of had two questions, I guess. One was in relation to how you handle the Geneva non-parties, and the other is more about the question that you posed to us about what we do with these people. So it seems to me that if the process is already in question, and so if we're looking at it in terms of due process, whether these people have been in any way legitimately classified as combatants, and what that means to be a combatant is also up for question. If our choices are extraordinary rendition risking torture or bringing them into the United States, which would simply allow them habeas petition, which is what due process, why is it such a huge, I understand the political kind of fire that would create, but why is it so threatening to give these people legitimate due process when the only alternative that we see is something that most countries that are civilized in the world consider an obvious human rights violation?
First of all, extraordinary rendition does not presuppose torture. They are two different questions. They both raise lots of questions, but they're not coextensive. Secondly, and thirdly, I guess, the questions to be asked in a proceeding as to the detainee treatment are set forth in the Detainee Treatment Act, and a process is provided there for taking them through military tribunals, for handling the classified information involved, and for reaching a decision. Now, whether it's an adequate substitute for habeas or not, I'm not about to express an opinion on, because the Supreme Court is probably going to express an opinion on. Their alternative is they will say, well, there are habeas rights here. We're going to send it back to Court of Appeals for the D.C. Circuit to decide whether this is an adequate substitute. And I will honestly say to you, I haven't decided that yet. Not have I not only published it, I have not published it, I've not decided it. The difficulties in having habeas proceedings in the United States, a lot of them are practical, some are theoretical. What else are you opening the door to when you say that you're giving alien, unlawful, non-citizen, unlawful combatant enemies of the United States constitutional rights? What other constitutional rights do they have, and what tests of evidence are going to be balanced? The practical difficulties include you have a world of classified information on how many prisoners are now held. I don't know. An awful lot of people to go through classified information proceedings in our courts. We have fairly small federal courts. We have other things on the docket. So the practical matters include we're not a big enough boat to handle that problem. The second includes that these are not normally justiciable questions. Who is an enemy? There is no role for the judiciary in deciding that in the first instance. Now, in the Bass v. Tingey case, the court was faced with deciding whether France was an enemy when there was no declared war, and Washington and other justices had no problem saying, well, they're out there shooting at each other. If it's not an enemy, I don't know what it is. It's certainly not a friend. But the underlying question of who do we make our enemy is not a question that the courts have any history of answering or any constitutional authority to answer. So that's going to be the first question in deciding who's an enemy combatant when we don't have a nation state. So it's questions more of politics and international relations than it is of the things courts normally do. That doesn't mean we can't do it, but it does mean it's not the norm for us to deal with that. I doubt if that answered your question, but it's about as well as I'm going to answer it. Oh, you're going to cut it off?
Do we have one more question? Let me suggest to you that Judge Sentelle said he was going to pose a lot of these as questions without answers. To be honest with you, that's the nature of national security law now.
Yeah.
And he and I have to rewrite our teaching notes about every semester.
Yep.
Something you may not have realized is that as Judge Sentelle was speaking, particularly about the hugely significant case of Boumediene or however all your litigants pronounce it, Judge Sentelle, along with Judge Randolph on the court, was the authors of that opinion that now the Supreme Court is considering. So when you heard him speak about that case, he spoke within the context of teeing it up for the Supreme Court. Judge Sentelle was also the author judge of a case that you've been reading about very lately, that the Supreme Court heard oral argument in a couple of cases called Omar and Munef, involving U.S. citizens being detained by U.S. military authorities in Iraq with a prospect of being turned over to the Iraqi courts. And it was his opinion, very short, that basically suggested that there's a World War II precedent, Supreme Court precedent in the Hirota case, that maybe the Supreme Court, and I don't want to put words in your mouth, Judge, but maybe ought to reconsider or think about it.
I think I almost said, I'm not sure the words I used, that we cannot detect the reasoning of that case, but it's a Supreme Court case that tells us we don't have that jurisdiction. We can't change it. The Supreme Court can. And the litigants then immediately took it to the Supreme Court. They heard argument. It's now pending.
That's what we call teeing up an opinion. Anyway, if this has whetted your appetite or your thirst for this sort of thing, I do want to make sure all of you know, if you haven't found it on the website, that 2 weeks from today, right next door at the Geneva Auditorium, there's a totally free conference, which we are offering, on combating terrorism, charting the course for the new administration. Judge Sentelle will be on a panel dealing with prosecution of alleged terrorists in the federal courts, chaired by my colleague, Sarah Beal. And immediately thereafter, I will be chairing a panel on, guess what, extraordinary rendition, including having Mike Schur down from the CIA, who created the program for President Clinton in 1995, and we will be probing, perhaps in a little bit more depth than we did today, this whole question. So I invite you, if you haven't heard about this conference, it's on the website, but also additional information is available either from me or from Balfour Smith down in 3021. Totally free. It costs you nothing, and you don't have to attend the whole thing. But it will be an interesting discussion on these and other issues. So Judge Sentelle, again, thank you so much for your comments today. We appreciate it.
Thank you very much.